My pens have all walked off. Peter, do you have one? Okay, I'm waiting for everyone to make an audio connection and we'll go on the record. All right, looks like everyone's here. Nadine, you can put us on the record. This is the matter of Rowley versus Keller. Mr. Fallahy represents the plaintiff. Ms. Rowley's present and Ms. Keller is present. And Mr. Fallahy, remind me where we left off.
Judge, I appreciate you asking that question. I was going to ask you the same thing. Judge, my recollection is that my client has testified and that Ms. Keller, I think, was in the middle of, I was in the middle of questioning her when we ran out of time the last time we had appeared before the court. And so I think that Ms. Keller is still on the stand from the last time here. The court had indicated at the last hearing that it expressed some concern about whether the my client, in this case the plaintiff, had met her burden by a preponderance of the evidence to show that the mother's decision, in this case Ms. Keller, to deny grandparenting time created a substantial risk of harm to the child's mental, physical, or emotional health. So that's where I think we are from where we left off in late January, Your Honor.
Okay, so Ms. Keller, you understand that you are still under oath?
Yes, I do, but we left off with Kimberly bashing me.
Are you saying she was testifying when we left off?
Yes, that's where we left off. We took a break because Mr. Fallahy was trying to find something to get it to go in her way. And then they said to prove me unfit.
All right, Mr. Fallahy, do you have any further questions for Ms. Keller?
Your Honor, I just have a couple, yes.
All right, so ma'am, you're under oath. He's going to ask you some questions.
Okay.
Ms. Keller, have you given any further thought to the children having some grandparenting time with their grandma Kim?
No, I'm not.
Okay, and just to recap a little bit of what happened last time, your position is that you want these children, and that's Bailey and Stormy, and I think that Bailey's 14 and Stormy is 10, correct?
Correct.
You want both children to have no contact whatsoever with their grandma Kim, is that correct?
Neither children want to have contact with Kim.
And I understand that's your position, but the question I have is it going to be your decision that these children have zero contact with their grandma Kim?
Yes.
Okay. And again, what is the basis for your decision?
Because my kids don't need to be around somebody who's vindictive and tries to talk bad about people just to get her way.
Any other reason?
And she sneaks around, she lies, she comes to people's houses when she was told not to. She brings other people to your house. She sends things in the mail. She gives my phone number out. She calls off a million different numbers. She has other people.
I'm sorry, Ms. Keller, was somebody in the background talking there
No.
with you? No. Okay. Is
No.
anyone else in the room with you right now?
No.
You don't look too sure of your answer. Are you sure there's no one else in the room with you?
I'm positive nobody else is in the room with me. I'm mad because I have to be to work in 15 minutes.
Okay. You also, Ms. Keller, don't dispute the fact that the children, when they were younger, had a very close relationship with their grandma Kim, correct?
Oh, they had a very close relationship. What, when Kim moved to California?
Ms. Keller, just
No,
try to
they didn't have a close relation. No, they didn't ever have a close relationship with Kim. They seen Kim off and on throughout their entire life.
Okay, and she actually took care of them for a period of time while you were either in
No,
jail or
she
otherwise unavailable.
no,
Hold
Kim
on.
never once took care of my kids.
Ms. Keller, hold on. You need to let Mr. Falke ask his whole question and then answer the question that he asked. Don't interrupt him. You can complete your question, Mr. Falke.
Thank you, Your Honor. My question, Ms. Keller, was just that isn't it true that these girls had a very close relationship with their grandma Kim when they were younger?
No, their relationship has been off and on their entire life.
And what do you mean by off and on? How do you describe off and on?
Off and on, Kim would come when she didn't have a boyfriend. When she got a boyfriend, my kids was obsolete. When she got a boyfriend that she wanted to introduce to my kids, she wanted to be around my kids. It's been like that their entire life.
You would agree that the children would spend holidays and other significant parenting time with Grandma Kim and that side of the family, correct?
Yeah, when they wanted to go out there.
Okay. And they would do pumpkin carving at Halloween, and they'd go over for Thanksgiving, and they'd occasionally go over for Christmas and other holidays, correct?
They would occasionally go for Thanksgiving and Christmas. Yes, I don't remember no pumpkin carvings.
Okay. You heard Ms. Rowley, Grandma Kim testify about that last time we were here, correct?
Yes, and Bailey was sitting next to me and said we'd never done pumpkin carvings.
Okay. All right. And what would it take from your position to allow for some contact between your daughters and their Grandma Kim?
Nothing.
There's nothing that could be done that could allow contact between your children and their Grandma Kim, which would also result in them having contact with their half siblings, correct?
Okay, and I'm not the one who put the stop to their half sibling thing. Their mother did when their dad died.
Whose mother? The half sibling's mother?
Yes.
Are you willing to facilitate that relationship after court where the Stormy and Bailey can have a relationship with their half siblings?
No, after you contacted me the other day, it's pretty funny. Amber got my number and asked the same questions you asked.
Amber is the mother of the other children, the half children.
Yes.
And what exactly have you two talked about recently?
She asked the same thing you asked, if I would meet in a public place or at my place or anywhere for the kids could see each other, and I told her no.
Okay, and why did you deny that request?
Because Amber took that away from herself 6 years ago when their dad died, when she pulled the kids out of my home.
I don't know what you mean by that. What do you mean by that when she pulled the kids out of your home?
Because I had them kids every other week. And when he died, she took them out of my home and said they didn't need to see their siblings because they wasn't my kids.
When was the last time Stormy and Bailey have seen their half siblings?
It's been a couple years.
You mentioned 6 years just a minute ago. Has it been a year or two, or how long has it been since they've seen?
It's been since they went to Kim's house on Christmas 3 years ago, 2018, I believe. 2017.
Okay, so two or 3 years, somewhere in there.
Yeah. Yes.
Do you think it's important at all for Bailey and Stormy to have a relationship with their half siblings?
Yes.
And do you think it's important for Bailey and Stormy to have some type of a relationship with their father's side of the family?
Yes.
And so I guess my question again is, what if anything can you do to try to facilitate that type of relationship?
I'm not going to facilitate when people are vindictive and liars. My kids don't need to be around that.
Okay. Are you willing to consider any type of supervised grandparenting time?
No,
Why not?
because I just said my kids are not going to be around vindictive liars.
Well, let's just assume for a minute that what you're saying is true and Grandma Kim is a vindictive liar. Wouldn't a supervisor for some grandparenting time be appropriate to ensure that she's not talking to the children about something she isn't supposed to be?
Yeah, and why should I have to put my kids through that? They ain't in foster care or anything. They said no, they don't want to see her.
Well, that's what they've told you, Ms.
No,
Keller.
they talked to the judge. They
Well,
had
how
an
do you-
appointment with the judge back in December.
Well, were you present in the meeting with the kids and the judge?
No, I was at work and the judge asked for it to only be him and the girls. They did one-on-one with the judge through Zoom.
Okay, and you were not present for that, correct?
Correct, I was at work.
So you don't know exactly what was said, correct?
I know what my kids told me when I got home.
Okay, so that's how you know is what they told you after you got home, correct?
Correct.
Okay. Thank you, Ms. Keller. I don't have any further questions for you.
Okay.
So, Ms. Keller, normally at this point, if you had counsel, he or she would ask you if you wanted to expand on anything that Mr. Fallahy questioned you about. Is there anything that you want to address or respond to based on the questions that he asked you?
No, but Your Honor, the last time we were in court, Kim was requesting I did a drug test, which I refused because I go to the doctor every month. I can email you my results from the doctor every month.
Anything else?
No, Your Honor.
Any further presentation, Mr. Fallahy?
Judge, if I may, I'd like to recall my client just for a question or two. It shouldn't take long.
Okay. Ms. Rowley, you understand that you're still under oath.
I do.
Go ahead, Mr. Fallahy.
Thank you, Your Honor. Ms. Rowley, can you hear me okay?
I can.
All right. And just to recap, I want to make sure the recap I gave to the court is correct. You had testified previously at our hearing, is that correct?
Yes.
And you went through in great detail the connection that you had, I guess, with Bailey and Stormy before they were prevented from seeing you, correct?
Yes.
And that included a significant amount of time that you essentially took care of these two kids while their mother was unavailable, correct? Both during the summer, during the school year, you'd see them on the holidays. There was a significant connection between the girls and your family. Is that correct?
Yes, that's correct.
Your Honor, I object to that.
What's your objection?
She has never taken care of my kids. When I couldn't take care of them, they lived with my mother.
Ma'am, that's not a valid objection. The fact that you disagree with the testimony is not a basis for objection. I can hear her testimony. I can hear yours. I can decide based upon that who to believe, but it's not a valid objection to just say you disagree with what she's saying.
Okay.
So your objection's overruled.
Ms. Rowley, just specifically too, in your complaint.
Hold on,
Oh.
Mr. Fallahy. I got it.
Dawn says you can hear everyone except you on the monitor.
Dawn, can you hear me now? I think it was on mute.
Okay.
Did you get anything from
I
her?
didn't get it.
Let's find out and make sure. Because I think somebody mentioned that when Judge Claren was using my courtroom that they weren't able to hear him. Is it working?
Not right.
It's not?
You can't hear that? You can hear when you turn
Well, I know that microphone picks me up. Actually, it's right here. It's not muted. I wonder if something got unplugged while they were up here messing around.
Yeah.
This one has no control on it. This one's got a, I think when the red light's on, it's muted, and it
No,
wasn't.
wait.
How's that?
She can hear now.
Oh, it just wasn't close enough. I didn't notice, but Judge Claren had slid it over to the side.
Right.
All right, sorry about that. Was it showing up on the recorder when I spoke? Oh, okay. All right, sorry about that. I wanted to make sure our sound system was picking me up.
No problem. Thank you, Your Honor. So, Ms. Rowley, do you think it's important for Bailey and Stormy to be able to keep, I guess, at least a memory of their father who passed away a few years ago?
Do I think that's important?
Yes. And why do you feel that? Why do you feel that way?
Well, because he was their father and they were very close to their father. I'm pretty sure that they will not forget their father, whether they saw me or not. They have that image and that memory in their head, and I think that's good. Yeah.
Okay. And I know you, again, went through a lot of testimony the last time we were in front of the judge, but is there anything else that you'd like to say to kind of sum up your testimony from last time, or anything else that you'd like to tell the court that you didn't get to testify to in late January?
Yeah, I do have a point I would like to make. I didn't intend for this to become a character assassination of myself, Ashley, or Scott. And I don't care about drug tests, and I don't care about who loves who more or who hates who more. All I care about is seeing my granddaughters and my granddaughters having a relationship, a full, rich, all encompassing relationship with their siblings, most of all, and with my side of the family, their father's side of the family, which they had at one point, and that was taken away for just stupid reasons. I do want to take this opportunity. When Ashley called you immediately after our last hearing, she said, Kim knows what she needs to do to see the girls. And she said this repeatedly to me and through the girls to me. And I would, however, like to take this opportunity to tell her I apologize sincerely for not picking her up and taking her to the store on January 29th of 2019. And I apologize sincerely to Scott for saying he was mean to the girls and calling him an asshole. That's what this is all about. I lost my brother this past week, and as with the loss of my son, I am learning painfully what to fight for and what to put in God's hands. I know those girls love me beyond whatever anyone else says. Those girls love me, and they will find me when they are 18, when they're allowed to have thoughts of their own. And I'll be here. I will be here, and I will be waiting. And there's simply nothing else I can do but to leave this up to Judge LaFlamme and God.
And Kim, just again to tie into what we talked about last time, in your complaint for grandparenting time, you were just seeking to have that time maybe 1 weekend per month from a Saturday to Sunday. Is that correct?
Yes, it was a very small amount of time I was hoping for. Hoping that maybe it would progress into more, but I was willing to do just one small piece of time once a month.
Thank you, Kim. I don't have any further questions for you.
Okay, I think we're ready for arguments then, Mr. Fowley.
Yes, Your Honor. Thank you very much. Judge, we talked about the presumptions and the burdens of proof at the last hearing. And, you know, the way I understand the law at this point is that there's a presumption by a fit parent that it's not against the children's best interests and their mental, physical, and emotional health if a fit parent denies grandparenting time. Under the statute, which is MCL 722.27B, it indicates to rebut the presumption, a grandparent must prove by a preponderance of the evidence that the parent's decision to deny the grandparenting time does create a substantial risk of harm to the child's mental, physical, or emotional health. My notes and the information in the file leads me to believe that these two children had a significant and loving relationship with their father before he passed away, and that they also had a significant relationship with his extended family. And that has been cut off completely since late 2019 by Ms. Keller. It's our position from the plaintiff's perspective, from Grandma Kim's perspective, that continuing to completely cut off that grandparenting time or any connection with the father's side of the family would have that type of substantial risk of harm and would create that substantial risk of harm to the children's mental, physical, and emotional health. I would point out the case of Keenan versus Dawson. This is a Michigan Court of Appeals case. Citation is 275 Mich. App 671 from 2007. And in that case, the facts were similar to this, although the child was a little bit younger. But the trial court in that case found, and I quote, the court does find that this child has experienced such a tragedy in his life that it is critical to Alex's, that's the child, Alex's mental and emotional health to have additional support with regard to his maternal grandparents to enhance his memory and recollection, love and support that he received from his mother during the time she was alive and loved and cared for him. In the case at bar, we've got the reverse of that. The father has passed away. And I think that if this court finds that simply by a preponderance of the evidence, that continuing to have contact with their father's family, including Grandma Kim, would be a way to ensure that there is no substantial risk of harm to the children's mental health and well-being. And the court in that case, again, specifically found that just carrying on the memory and recollection and love and support from the time where the parent was alive was enough to rebut the presumption by a preponderance of the evidence. The trial court in that case went on to make a finding that the grandparents have proven by a preponderance of the evidence that the parent's decision to deny all access to the child will create a substantial risk of harm to Alex's, the child's mental health and emotional health. The Court of Appeals considered a lot of different, four different constitutional challenges from what I'm reading in that case to the decision that under the subsection of the opinion where it talks about an as-applied challenge. The Court of Appeals found that the trial court was not clearly erroneous in its findings in that case. And without getting into too many of those facts, it's an analogous case to what we have here. Unfortunately, Ms. Keller has, proven to be defiant. She does not want to work at all with the father's family. And if it were up to her, it sounds like there would be zero contact forever between these children and their father's side. And it's our position from the plaintiff's side that the complete and total lack of contact altogether is one that will create a substantial risk to these children. I would further point out that the Michigan Court of Appeals in the case that I referenced had differentiated that case from the U.S. Supreme Court case, which is the Troxel versus Granville decision, which kind of, from what I've read, led to a change in the language of the statute. And in the Troxel case, according to our Court of Appeals in Keenan versus Dawson, the issue there was not the Keenan v. Dawson case was, they were able to differentiate it because in Troxel, the argument was over how much grandparenting time, not between, it was not involving a parent who had completely cut off another side of the family. And that's what happened in Keenan and Dawson and Keenan v. Dawson, and that's what's happening here. So we would ask the court to find that the plaintiff, Ms. Rowley, has met her burden of proof. We did go through, from my memory, the best interest factors to a significant extent at the last hearing in late January. We would ask the court to order grandparenting time, again, just one weekend per month. That's not too much to ask in order to allow these children to continue having a memory and recollection of their father as they should. And, when they do get to the point, as Ms. Rowley just indicated, where they can make their own decisions. And for Bailey, that's in 3.5 years or so. And for Stormy, in about 7.5. We're confident that they'll come back to their father's side of the family at that time in a more significant manner. But for now, the request is, in our opinion, very reasonable and minimal. We'd ask that you find that the burden of proof has been met and order grandparenting time accordingly. Thank you.
Thank you. So, Ms. Keller, I realize you don't have the legal background to be able to address the case law or the statute, but you still have an opportunity to present an argument now as to why you believe that I should not order any grandparenting time.
I believe you should not, because last time Kim admitted that she was stalking us, that she was calling us, she was popping at my house when she was told no. She's ordered school pictures when she didn't have the personal code to get them, so she did something with the school to get their parent code. I've told her no. My kids said no. They don't want to go with her, and I don't see how that has anything to do with remembering their dad without seeing her, because they was seeing his side of the family when they was asking. They was seeing her brother Ed. They were seeing her daughter Sam. They were seeing Grandma Linda, Tom. Anybody who asked for my kids, get my kids. Sam and Ed quit asking for my kids and started using Kim as a middleman. That was their fault.
All right, thank you. So the court is now required to make a finding. The statute, as Mr. Fallahy has identified, provides very clearly that a court may not hold on. All right. Got my pages mixed up here. Okay, here we go. Under MCL 722.27B, a grandparent may seek grandparenting time if, in this case, the child's parent who is a child of the grandparents is deceased, and that is the case here. So that gives Ms. Rowley the absolute right to file a claim seeking grandparenting time. And then the standard that applies when she meets one of the categories is that the statute creates a presumption that a fit parent's decision to deny grandparenting time does not create a substantial risk of harm to the child's mental, physical, or emotional health. So that's where we start. Although there were concerns about Ms. Keller as a parent, the court does not find that there's any evidence in the record that would show that she's an unfit parent. So that's the starting point. So in order to rebut this presumption, Ms. Rowley is required to prove by a preponderance of evidence that Ms. Keller's decision to deny parenting time creates a substantial risk of harm to the child's mental, physical, or emotional health. The court believes that that standard requires more proof than simply the children at one time had a relationship with that grandparent. If that were the case, virtually every time a grandparent who meets the basic requirements for being able to file a claim would prevail. Being a grandparent myself, I have a very strong bond with each of my grandchildren, some of which I don't see very often at all because they live so far away. There has to be something more to overcome the presumption that there was simply a bond at one time in the past. Here, I don't doubt that at one time these children did have a very close bond with Ms. Rowley. It's not clear to the court that that bond has continued simply because of the passage of time. I did interview the children. I will not disclose what they told me, but certainly that is a factor in my consideration as to whether or not this standard has been met. I don't believe the evidence is sufficient to overcome the presumption. So I'm not going to order grandparenting time. But what I am going to do is strongly, strongly encourage that there be some kind of resumed connection with their father's family. I realize that there's been a lot of, I guess I can say, ugliness, that if it hadn't happened, probably today, Ms. Rowley would have remained involved with her grandchildren. And I don't mean to criticize Ms. Keller for cutting that off. I understand why she did that. I understand what her motivation was. It's unfortunate. I think the children could benefit from being able to see their grandmother it doesn't have to be a forced parenting time. I think there could be real advantages to them. I think some healing needs to take place. I I don't think it's good for your children, Ms. Keller, to have this wall, even though you were perfectly within your rights to be upset at this ugly confrontation that took place, and to be upset about sneaking around, trying to see them when you had specifically forbidden it. I understand why you feel the way you feel. I would hope that there would be a way that you could get past this. I do think your children could benefit from that, being able to see their siblings, their half siblings, being able to be connected with their father's side of the family. But I know that some healing has to take place in order for that to happen. And I would just strongly encourage you to receive Ms. Rowley's apology as heartfelt, and maybe even gradually find a way for your children to connect with her and to connect with their half siblings. I really think they could benefit from that. But my feeling that they could benefit from it is not enough to overcome the presumption that's in the law. So I'm going to deny the request for court-ordered parenting time, but I'm going to strongly encourage you to reconsider on your terms so that you can get past this. I think they could benefit from it. Thank you. That concludes our hearing.
Thank you, Your Honor.
Thank you,
Mr.
Judge. I'll
Fowler,
prepare,
okay, thank you.
prepare the order. Thank you.